Hi, my name is Ben Brady and I'm a Senior Associate in McCabe Curwood's Litigation and Dispute Resolution Group. Given that the vast majority of litigated matters settle before trial, documenting the terms of settlement, which ordinarily contain releases from liability, is a commonplace feature of litigation practice. The recent case of Wichmann v Dormway, delivered by the Court of Appeal of the Supreme Court of Queensland, serves as a timely reminder of the care that must go into drafting and negotiating release clauses, and particularly the scope of any release that may be given. In that matter, the appellant, Wichmann, had been employed by the respondent company, Dormway, as an office manager. In that role, she had been responsible for managing the respondent's accounts. This enabled her to falsify the accounts in order to divert the respondent's money into her own bank account. Initially, Dormway discovered that Wichmann had misappropriated $2,809. Having discovered this, Dormway decided to terminate Wichmann's employment, despite her offer to repay the money. As a result, on 30 April 2018, the parties executed a deed that contained the terms of the appellant's departure. These included payments to the appellant by way of redundancy payments and a reimbursement to Dormway of the sum of $2,809.42. The deed contained mutual releases as well. Shortly after the deed had been signed, sealed and delivered, Dormway discovered that Wichmann had in fact stolen $321,593 and it commenced proceedings against her to recover that sum. Wichmann defended the proceedings upon the basis of the releases given in the deed, which precluded Dormway's claim, it was alleged. The company's claim was successful at first instance and Wichmann appealed. Since as long ago as 1751, it has been settled law that a release would be construed so that it related to the particular subject matter that was in contemplation of the parties at the time that the release was given. President Sofronoff delivered the lead judgment, with which Justices Goddison and Morrison agreed. His Honour had regard to the following relevant principles in dismissing Wichmann's appeal. 1. A release will be confined to the subject matter contained in the recitals. 2. A release is to be construed so that it is confined to the known disputes between the parties. And 3. It would be unconscientious for a party to rely upon a release obtained when the releasee knew of a liability, later sought to be enforced, but the releaser did not know. His Honour also noted an additional fourth basis that would preclude reliance on a release clause, where the releasee knew of a liability and which the releasor was unaware and was under a duty to disclose it to the releasor before entering into the deed, but did not do so. Critically though, the court also held that liabilities that are not known to the releasor can still be within the scope of a release clause, provided that the language makes the intention plain. The key takeaway from this case is that releases in general terms will be construed narrowly, but nonetheless, releasors should be very careful to ensure that they do not unwittingly agree to provide a release that could evince an intention for the release to apply to unknown liabilities, because this may displace the general rule. Don't hesitate to contact McCabe Curwood's Litigation and Dispute Resolution Group if you require assistance in relation to a potential or actual commercial dispute.